Welcome to this UK employment law presentation, written by Hailwood Employment Law. Today we are going to be looking at the contract of employment and the employer's obligations. We start off by explaining what a contract of employment is, before looking at the requirement imposed on employers by the Employment Rights Act 1996. A contract of employment is created as soon as the employer and potential employee agree on the main terms under which employment is offered, for example, pay, hours of work, holiday entitlement and the nature of the work, and the offer of employment by the employer is accepted by the potential employee. There is no requirement that the contract of employment is produced in a written form or signed by either the employer or employee. Once the terms of the contract are agreed, they cannot be changed without the consent of both the employee and employer. The fact that there is no legal requirement that a contract of employment must be in writing, can, of course, lead to future disputes about what was agreed. The Employment Rights Act 1996, Era 1996, makes it a statutory requirement that all employees are issued with a written statement of their principal terms and conditions of employment. Section 1 of the Employment Rights Act provides that an employee must be provided with a statement of initial employment particulars within 2 months of the commencement of their employment. The Act then details what must be included in the statement. The statement of initial employment particulars must include the name of the employer and the employee, the date employment began, the date on which the employee's period of continuous employment began, the scale and method of remuneration, the intervals that remuneration will be paid, the hours of work, terms and conditions relating to holiday entitlement and bank holidays, job title and a brief description of the work to be undertaken, the place or places the employee is required to work. It must also provide details of the following but may refer to other documents: terms and conditions relating to sickness and sick pay entitlement, details of pensions and pension schemes, provisions relating to notice to be given, where the employment is for a fixed term, the date employment will end, whether or not the employment is subject to a collective agreement, where an employee is expected to work outside the UK, various details relating to pay and conditions, details of grievance and disciplinary procedures. Where a dispute arises about the terms of the contract, a court or tribunal will look at the statement of terms and conditions, which, whilst not the contract, is evidence of what the terms of that contract are. The court or tribunal may rely on supporting information such as the original advertisement for the post and any job offer letters and any other document which appears to indicate the terms of the contract, in addition to hearing evidence. Presented by Hailwood Employment Law. Contact us today to find out more about our services.